Is the federal restriction on 18 through 20-year-olds' ability to purchase handguns unconstitutional? Well, yes. And a judge just agreed the other day, and this case is going to be monumental in the fight to return the country to what it was supposed to be before it was bastardized by government. Before I jump into it, I want to thank the sponsor of the video, Blackout Coffee. Guys and gals, Blackout Coffee, the best in the country. If you don't believe it, just try it. And because it's our Labor Day sale, I'm going to tell you how to save 23% off site-wide. Head over to the link down below. It's blackoutcoffee.com/GNG and use code LaborDay23 and save big. You're welcome. You don't have long to use that, so jump on it ASAP. I want to thank all of you for helping this channel push through this little lull. YouTube has, I guess, decided the news shouldn't get out. So if you think the Second Amendment is extremely important, more important than YouTube or Google's desire to suppress the information, then like the video and subscribe to the channel down below. It helps. Trust me, it really does help. All right, for this case, we're going to talk about, it was we first started talking about this, I think it was like a year and a half ago, and in May, a judge gave a ruling on it, and there was an update to this ruling a couple days ago, 3 days ago. And it's Frazier versus ATF, and this is a case out of Virginia, and it's some 4 individuals, I believe, if I remember right, that are in the age group of 18, 19, and 20 years old, and they're challenging the constitutionality of 18 U.S.C. 922, certain sections of that limit the right to purchase a handgun to somebody who's 21 or older. Now, they fought valiantly in this to fight for their rights, and they won. A judge agreed with them, saying that there is no text, history, or tradition in this country's policies, rules, laws, the Constitution of this type of firearm regulation. In fact, those age groups were required to be armed because you never know when you might have to fight off the British or anybody else trying to be tyrannical, including our own. And in the process of that ruling in May, the judge said this is going to be treated like a class action lawsuit. And that class, that certified class, is everybody in this country who's aged 18, 19, and 20-year-olds who is not already prohibited from being a firearm owner. The judge fought back against the government's claims. The government went crazy on this, saying, hey, Your Honor, this doesn't violate the Second Amendment right for a few reasons, because they can still get a gun. They can be gifted one. And the judge did excellent on this. The judge was like, yeah, well, no other right do we have. Where is there an instance in where it's regulated to a third party's gift? The judge filleted the government on this case. Then they said, well, you know what, Your Honor, we don't have to do this nationwide injunction thing because eventually all these 18, 19, and 20-year-olds will turn 21, so that they're really not having their rights suppressed because they'll eventually attain that age. The judge was like, nah, no. The second that they're being restricted, their rights are being violated. And then the judge also said that the Second Amendment not only protects someone's right to possess a firearm, but it also protects somebody's ability to purchase a firearm. Let me show you a couple key parts of this case because I think this is very important for everybody to understand what's going on right now, where it stands right now, because this is going to be appealed, trust me, and this is going to be a major, major case. Okay, this is the case, if you need to see it, or the citation number, but it's known as Frazier versus ATF. Let's go to the background. This case is a constitutional challenge under the Second Amendment to an interlocking collection of federal statutes and regulations that prevent 18 to 21-year-olds from purchasing handguns from federally licensed firearm dealers. Plaintiffs are all men over the age of 18 but under the age of 21. Aside from their age, they are all otherwise qualified to purchase handguns. The defendants, the government, does not dispute that. Plaintiffs originally filed suit in June of 2022 and then filed their first amended complaint in November of that year. In November of 2022, the government filed the defendant's motion to dismiss plaintiff's first amended complaint. And in December of 2022, plaintiffs filed the plaintiff's motion for summary judgment. The court held oral arguments on the two motions on February 8th of 2023. On May 10th of 2023, the court entered an order and accompanying memorandum opinion denying the motion to dismiss and granting the motion for summary judgment. In the memorandum opinion, applying the mode of analysis specified in New York State Rifle and Pistol Association, Inc. versus Bruin, the court concluded that because the statutes and regulations in question are not consistent with our nation's history and tradition, they therefore cannot stand, meaning they're unconstitutional. The court ordered the parties to meet and confer on how to best proceed in this matter. Unfortunately, the parties filed a joint status report informing the court that they do not agree on how to proceed. The parties have filed dueling proposal final orders. What does this mean? Well, the judge said that the law restricting handgun purchase to someone 21 or older is unconstitutional. Now you guys get together and figure out how we're going to move forward with this. And both sides couldn't agree. The government was like, absolutely not. We need to restrict rights, Your Honor, because how can we be tyrants if people can be free? You know, basically. And obviously the plaintiffs were like, hell yeah, Your Honor. This needs to be struck down for everybody nationwide aged 18, 19, and 20 years old. Let's get rid of this. It's unconstitutional. Right? You can see how each side wouldn't be able to agree to work together. Well, that brought us to where we are as of 2 days ago. As explained in a separate memorandum opinion, the court has certified a nationwide class of all individuals between the ages of 18 and 21 who are otherwise qualified to purchase handguns. The government takes the position that, based on the memorandum opinion, granting summary judgment while reserving the right to appeal that ruling, plaintiffs' alleged injuries would be remedied by a declaratory judgment. The government would limit that judgment to the named plaintiffs only, meaning the actual people on this case. However, the government argues that plaintiffs have not satisfied their burden of demonstrating that the requirements for a permanent injunction are satisfied. Instead, the government, in defendant's motion for entry of judgment in a separate order, asks the court to declare only that plaintiffs John Corey Frazier, Joshua Clay McCoy, Tyler Dalton McGrath, and Ian Fletcher Shackley have a constitutional right to purchase handguns from federal firearms licensees, notwithstanding the federal prohibition on such sales to persons between the ages of 18 and 20. Here's where the judge starts to kick ass. In this case, the harm, which is the violation of the plaintiff's Second Amendment rights, extends to all members of the class. So the remedy must too. The court found the challenged law and regulations facially unconstitutional, thereby carrying out its duty to declare all acts contrary to the manifest tenor of the Constitution void. This voided legal regime may, therefore, not be enforced at all. In other words, the court's ruling does and must apply to protect the Second Amendment rights of all citizens between the ages of 18 to 21 who are otherwise eligible to buy a handgun. In no way was either the substantive decision or the class certification decision in this case limited or influenced by the fact that the named plaintiffs live in the Eastern District of Virginia, the Commonwealth of Virginia, or the Fourth Circuit. Indeed, aside from the procedural question of venue, this case's substantive outcome on the merits would be the same if the individuals resided on the opposite side of the country. In sum, people between the ages of 18 and 21 in the Eastern District of Virginia suffer an equal burden as the people of the same age in the Southern District of New York, the Central District of California, or any other district. The government's policies affect and harm each of them equally. Therefore, the categorical policies relied upon by the government call for categorical relief. Only a nationwide injunction will prevent irreparable injury to the plaintiffs who, since as class has been certified, include all American citizens between the ages of 18 to 21 who are otherwise qualified to purchase a gun. Now there's a but. It's a very small but it's not necessarily a bad but. However, In recognition of the currently pending parallel litigation concerning the challenged legal regime, the injunction will not apply to the Western District of Louisiana and the Northern District of West Virginia. That means that there's lawsuits pending in those areas, and they're about to come to a head as well. While this nationwide injunction may be geographically broad, it is no greater than necessary to afford relief to the certified class. Conclusion: for the reasons set forth above, plaintiff's motion for declaratory judgment and injunction will be granted, and defendant's motion for entry of judgment in a separate order will be denied. And this is Robert E. Payne, Senior U.S. District Judge, Richmond, Virginia. So this is a huge decision. The judge got it right. I'll have the decision linked down below. It's a good read because the government tries and the judge just pounds them, which is phenomenal. Finally, judges are starting to do what they should have been doing all along because they have the Bruin decision, thanks to the U.S. Supreme Court's decision. Guys, this is a good one. The government will appeal to this. They're not going to take that loss easily because this is a huge loss. 18 to 20-year-olds, there's a nationwide injunction right now by this judge that says they can buy guns at FFLs. There's no textuary tradition ever to stop that other than your tyrannical law, and that's unconstitutional. So this judge, Robert Payne, thank you. Protect this judge, Virginia. This is big. This is a huge case. I will keep you up to date on the appeal that I know is coming, and I'll keep you up to date on the further decisions on this case. But as of right now, that's those sections of 18 USC 922 that have said that ages 18, 19, or 20-year-olds who are not prohibited federally, then they can't buy a handgun at an FFL. That's unconstitutional and is a nationwide injunction. Phenomenal. Guys and gals, please help this information get out. Like this video, share this video, subscribe to this channel down below. Thank you for your time. I hope you have a fantastic day. And don't forget, blackoutcoffee.com/GNG. Use code LABORDAY23 to save bigly. I'll see you all on the next one. Take care.